That $99 LLC you filed online, well, it could be the most expensive mistake of your investing career. Let me show you the loopholes that lawyers use to pierce it and how you can close them today. Hey, my name is Clint Coons. I'm an attorney, real estate investor, and I'm the guy who has helped protect over 40,000 doors from lawsuits and taxes. So if asset protection, anonymity, and smarter tax moves are your thing, then make sure you hit the subscribe button below so you get my latest content. All right, let's get started. You see, every week I hear from real estate investors telling me, hey, Clint, I'm safe. My rentals are in a limited liability company. And every so often I see investors who have lost everything because they relied upon a single layer entity strategy or online filing services that never told them the rest of the story. If you recently saw my video that I just released about a defective LLC operating agreement, it is stories like that that create the problems that come up when people lose their assets. You see, an LLC limits vicarious liability, meaning accidents inside dealing with the property. But the fact of the matter is that claimants can still come after you personally if you make these mistakes. All right, number one, personal guarantees on loans or leases. You see, if you are able to go out there and get a loan in the name of your limited liability company to buy a rental property, or maybe you bought it in your own name and you had to give a personal guarantee and then you transfer that property in the LLC, well, guess what? If something were to go wrong with that property and you defaulted on that note, then the bank will come after you personally because you gave a personal guarantee, and it does not matter if that LLC owns the property. Another problem people make not understanding LLCs and the asset protection has to do with negligent acts. Let's say, for example, you have a tenant and the tenant tells you, hey, it smells really moldy in the laundry room, and you continue to ignore that claim by the tenant and you do not take action to fix it. And then eventually they discover there's toxic mold in the property, and then they experience respiratory issues. Well, from that, they could turn around and they'll sue. And people think, well, the property's in a limited liability company. That's why I put it in there, because I know mold claims are not covered by my insurance. So I realized at the outset I had to get my property protected. But the problem is you were managing that property and you were made aware of the fact that there was mold in the property and you didn't take action to remediate it. So even though the LLC owns the property, you as the party that is managing that real estate would be individually liable for the claims. And so this means that they can move beyond the LLC and attack you individually. Other problems you have with limited liability companies that people don't talk about: tax obligations. All right, so even though you have an LLC set up, if you owe state or federal taxes, the LLC will not protect you from that. The federal government can go after the responsible party, which is going to be you if it's your LLC. If you have employees, and this isn't on the real estate context, but for those of you who have your own business set up as an LLC, know this. I've personally dealt with clients who have gone through this process where they've had employees who have sued the business and then sued the individual who owns the business for failure to pay payroll taxes. Generally, this comes up in situations where an employee will say, oh, you treated me as an independent contractor, and by looking at it, I should have been an employee, and then they come after you. Or if they work overtime and you do not pay them overtime. And it doesn't matter if you didn't even know they were working overtime, because maybe they were changing shifts, like what happened with one of my clients in California. 2 employees were shifting their shifts and they ended up working overtime. And then when she found out and she fired both these individuals, they turned around and sued the business and her personally for the fact they were not paid overtime. And then commingling funds. That's another way in which you can pierce the LLC, and it's not going to protect you. You know, those Starbucks runs that you use on the LLC's debit card or credit card? Well, hey, those things, little things like that can add up. So a lot of business owners do not understand this, and they tend to put a lot of personal expenses, however small they may be, on the business card. Listen, you've got to document things properly from a tax standpoint to make sure that you can show that it is a legitimate business expense. Otherwise, this opens the door for someone to pierce your company and come after you individually. So know this, the LLC is not a lawsuit force field. Okay, the second myth is all LLCs are bulletproof. Well, let me tell you, it depends on where you set up your LLC and the type of limited liability company that you're using. You see, a lot of online gurus skip the fact that many courts treat single member LLCs in specific states as sole proprietorships, and so they do not provide asset protection for the individual owners of those LLCs. Now, there are other states that do protect them, and part of a core asset protection strategy for real estate investors many times is using these types of structures, these single member LLCs, to hold our investment properties. But if they're not set up the right way, in the right jurisdiction, that is the entity you're holding, then you could find yourself in a situation where someone's bringing a claim either against you personally, because maybe you were involved in a car accident or it's a personal dispute, and a judgment's entered against you, then you lose the LLC and the assets that are held inside of it. Or the reverse is that the property's inside of a limited liability company, that somebody's injured on the property, they sue the LLC, and the court looks at that LLC and they look at it as an extension of yourself, and they choose to ignore the form and hold you personally liable. So what's a simple fix for this type of planning? Well, make sure you're using LLCs, that is owning LLCs that provide this level of protection, that specifically state in their statute, such as Wyoming or Delaware, that single member LLCs offer asset protection from your personal creditors. And what we're looking for there is that they hold that the charging order is the exclusive remedy. That is a sure signal that, hey, if I have or if I'm a member in this type of limited liability company and something were to go wrong, then I am not at risk of losing my LLC interest. Okay, the third myth, I don't need formalities because it is a limited liability company. Listen, I hear this a lot from online gurus. They talk about the benefits of using an LLC, that once you set it up, it's unlike a corporation, that you don't have to do meeting minutes and things like that. Well, I can tell you that is bad advice. You see, a limited liability company, many times courts will look at that like a corporation. They expect if you're running as a business, you're going to follow certain formalities. Even though the statute does not outline that you have to have certain formalities in order to maintain your LLC, courts will generally impose that upon individual business owners in the event of a lawsuit if they're looking for ways to pierce the company. So skipping the resolution, skipping the minutes, and you might as well hand your plaintiffs a checkbook. So courts are looking for these formalities, and so we want to make sure that we're documenting things properly on an annual basis. What the other opposite of this is that maybe your operating agreement states you have to do things and you're not even aware of it. For example, that video I talked about earlier, and there's a link right here. If you look up here, I'll put a link to that video where I went through an operating agreement and I showed you all the problems with that LLC. So in that particular operating agreement, it stated that the members will have annual meetings. That is a huge problem because, yeah, you need to have formalities. You should have an annual meeting, but then to specify in an operating agreement that you must have it puts you at risk that if you don't have it, now you've got a serious problem because you're not following your operating agreement. So you do need formalities, but you want to make sure that your operating agreement doesn't force it upon you. Okay, you want to ensure that you're documenting things as they come up. So what am I referring to here about documentation? All right, let's say I wanted to go out and buy a piece of property. Then you should have a resolution stating that the LLC intends to buy a piece of real estate. All right, if you wanted to sell a piece of real estate, or if you wanted to get a loan against that or refi the property, those are all things that require resolutions. Generally speaking, on an annual basis, you should have a meeting of the members to discuss how the business is going, how it's been operating, things you could do to possibly improve the business, just to show that, hey, I'm focused on this business. The benefit of having formalities goes just beyond the asset protection side as well. It also helps you from an audit standpoint. Listen, the IRS doesn't like any tax, or they look at taxpayers, and what they really like is to find taxpayers who do not follow formalities in running their business, because that allows them to come in and put you in a different tax bracket, meaning maybe you're claiming to be a partnership or an S corporation. They say, no, that doesn't apply to you because you're not following certain formalities. We're going to treat you as a sole proprietor. So these formalities not only protect you from an asset protection standpoint, they also provide benefit from a tax standpoint as well. Okay, the fourth myth that I see out there on the internet that is a problem for real estate investors is those people that tell you to place several properties in one LLC and just load up on insurance. Now listen, nothing can be further from the truth. And I'll give you an example of this. So many years ago, there was an individual, let's just call her Sarah. She was self-managing 5 rental properties held inside of one limited liability company. Well, she did a remodel on one of her properties and she had a deck installed on the property. Now, after the people got done installing the deck, they left. And she was out there inspecting the work, and as she was walking underneath this deck, because it was 2 stories high, what she found were a bunch of lag bolts in a box that was left there. Now she didn't think anything of it, and what she did, she just put these lag bolts into the garage and then rented out the property. Well, the tenant had a party, and they had a lot of people, 5 or 6 people out on the deck, and the deck fell away from the house, and all those individuals who were there, including the tenant, were injured. Now, here is the problem. That property was held by an LLC, so those individuals sued the limited liability company. But that LLC didn't protect Sarah. The reason why it didn't protect her is because they asserted that she had noticed that lag bolts or materials on the job site had not been installed. Now, of course, her defense is, well, I didn't know these had to be installed. But that's not the issue. She should have been more responsible and checked with someone, called the contractor. Hey, I found all these lag bolts. They weren't installed. Is there something I should do with this? But she didn't do that because that deck was not adequately attached to the house. That material was still there. She was put on notice, and she was held personally liable for that claim. So not only did she risk all of her properties by having them all inside of one limited liability company, the claim jumped the LLC and had her personally liable. All right, so what could she have done differently? Well, when situations like that come up and we're working with individuals, we like to take a strategy like this. What we're going to do is we're going to make sure that we create a holding company down here. So this would be the company that Sarah would be a member of. This is typically going to be a Wyoming limited liability company. And then I would have taken each of her properties, all 5 of those properties, and done this. I would create 5 separate LLCs and place each property in its own limited liability company as follows. And then each of those LLCs would be held by this one Wyoming limited liability company. Now, earlier I talked about the single member LLC problem. So each of these red boxes you see here, let's say they're all set up in Arizona. Okay, all of these are Arizona LLCs, and they would essentially be single member LLCs because the sole member is this Wyoming LLC. Now you might be thinking, well, Clint, you just told me single member LLCs are bad. In this context, it works. Why does it work? Because the single member of this Arizona LLC is the Wyoming LLC. You see, single member LLCs, where we run into problems is where an individual is the sole owner of that limited liability company. Because if Sarah were to be sued personally, let's say it's outside of the context of the deck separating from the house, let's say it's a personal obligation she had to a third party that she negated on. Maybe she made an offer to buy a piece of property and then she walked away from it and she thought, oh, only my earnest money is at risk, but then the seller sued her for failure to close. Well, in that particular case, if they get a judgment against her and she's owning a single member LLC like this, because it's Arizona, they could possibly take that LLC. So when it comes to single member LLCs, it's fine to structure them and use them in your planning, provided you're using a Wyoming LLC as a blocker entity. In other words, if you sued Sarah here, then the only interest she holds in any LLCs is in the Wyoming company. She doesn't hold an interest in these Arizona LLCs. So those single member upper tier LLCs are insulated or blocked from Sarah's claims. Now, Wyoming LLC right here, typically we would structure this as a partnership, okay, for federal tax purposes, and we would bring in another partner, maybe her spouse or someone else. But if that's not the case, she doesn't have anyone in her life, we can still use a single member LLC in Wyoming because, as I stated, Wyoming and Delaware are 2 states that specifically carved out in their statutes that single member LLCs are okay and they're protected from potential creditors. So make sure you're putting the structure together the right way. Now, the other benefit of using this type of planning is think in terms of layers and not in terms of single walls. Having the right stack of entities, like I'm showing you here, stops creditors, nosy neighbors, and even Google searches. And how does it do that? Because this Wyoming LLC offers you some additional protection that you would not get if all you were using was Arizona to hold your structures. And we see this a lot with real estate investors who do not understand the benefits of using Wyoming. You see, when you set up a Wyoming LLC, it offers you anonymity. And anonymity is your friend because when you use it in the right context, it can block your information from being disclosed on the Arizona Secretary of State's website, meaning this, that if a tenant looks at this LLC right here, they will never see your name. What they will see is this LLC down here, this Wyoming LLC. And so let's say we set up this LLC and we called it SmittyCat LLC. That was the name of the LLC, some just generic name. Now, if you're looking at this box, you're going to see this box down here. That's what I mean by stacking. And if you've stacked it right, then anybody looking here will never see you. So in this case, no one would ever see Sarah because when they look at the Arizona LLCs, they'll all list SmittyCat LLC as its single owner. And so having that anonymity shield is a critical aspect of putting together your entity stack in addition to the charging orders I just discussed. And it is one of the major mistakes that many people make when they're working with online gurus or companies that set up these types of structures. They do not understand the importance of this type of planning to prevent creditors from breaking the overall structures and getting after the assets. Okay, so I'm talking about entity stacks. Well, how about tax boosters? So here's something else. There's a bonus here when you're setting up structures like this, and that is you can bring in a management corporation up top. And again, this is another thing that's oftentimes missed when it comes to structuring. If you set up your own management company here, this could be a limited liability company. Typically, you will create it or tax it as a C Corp for federal tax purposes. What it allows you to do then is manage, oh, I messed that one up. It allows you to manage all of your various entities. And so by having that entity there as a management company, it'll then help you move money off of your personal tax return and onto a corporate return. Now, why would you want to move money into the C Corp and get it off your personal return by having this management entity here? Is because when the money moves into the C Corporation, guess who works for that company? That is, who is out there running this management LLC? Well, it would be Sarah. She's the one running her own management company that is dealing with her tenants. So she gets this benefit. Less income flowing down to her to be taxed at her higher tax rate. Income flowing into a corporation that she is then going to use for her personal benefit. You see, one mistake that people make when it comes to rental real estate and building out their portfolios or businesses in general, they do not understand this concept and they have to become familiar with it. And that is to earn money, spend money, and then pay tax on anything that's left. So many of us, when we start off in building out our structures, we do just the opposite. We flip-flop these two right here. We earn money, we pay tax on that, and we spend what's left. By bringing that management corporation into your overall entity stack, you're now able to take advantage of the corporate tax benefits that are available to business owners, far more than available to a solo practitioner or a sole proprietor, somebody who's doing everything in your own name. This is where savings occur. And so if you're an individual who has several rental properties, you need to look at using a management entity as your tax booster. Okay, what not to do? Well, listen, I know many of you who are watching this video now have maybe already set up a limited liability company, and when you were setting up your LLC, if on that website of the company you went to create it, you saw something that said, set up your LLC in 6 questions, or maybe it was a $99 corporation or LLC formation, or here's another one you'll oftentimes see. It includes a customizable website powered by Wix or a free consultation by some accounting company. Those are all red flags when it comes to LLC formations, because what they're telling you is that those companies are going to do the bare bones minimum that's required to get an LLC filed for you. And they're not thinking through the different iterations that can come to bear in the event you're involved in a lawsuit, because it's more than just doing the filing with the Secretary of State. You have to draft an operating agreement, and that operating agreement needs to reflect the type of business activity you intend to engage in. And if it's rental real estate, there are so many provisions that are crucial for a rental real estate LLC to ensure that it's going to protect your assets. And when we review these types types of operating agreements. I often refer to it not as legal Zoom, but legal doom for those individuals, because it all works until it's challenged in court, and then you find out what the problems are if you didn't take the necessary steps and actions ahead of time to put it together with somebody who actually truly understands what you're trying to accomplish and builds an operating agreement around that. So hey, if you've made it to this point and you're ready to bulletproof your portfolio, here's what I got for you. Download my free entity layering checklist. The link is below in the show notes. And if you want a custom plan, book a strategy session with my team here at Anderson. We've got a link down there. It's completely free. And remember this, plan now or pay later. Anderson will make sure that you've got the right plan in place. Book that strategy session now, and I look forward to seeing you on the other side.